Yes.
Please, the Lordship. My Lord, I beg to mention one IA Lordship, which was already mentioned on Monday, Lordship, for today, but it was not listed. Again, I am mentioning for tomorrow, Lordship, if possible.
Tomorrow? Why tomorrow?
I pray, Lordship, the accused is 73 years of age, Lordship, and suffering from
Monday,
for Friday,
tomorrow's list already clear.
for Friday, Lordship, if possible.
Monday.
Mark Lord,
This petition may come up for orders on Friday, Miller.
What is this
One
matter?
contempt petition is pending, Miller. It's a review petition.
Review.
Most of it.
May please, Your Lordship. I beg to mention item number 27 of today's list.
Yes.
I am appearing on behalf of Ms. P. Burman as she is suffering from severe back pain. So matter may be adjourned for today.
I am for the respondent, Miller.
Okay, right.
After
This
vacation,
has to be sent to the
already
mediation.
Mediation failed, Miller.
mediation failed, yes.
Okay, right.
After vacation.
Uh, adjournment prayer has been made on behalf of Mrs. P. Burman, learned counsel for the appellant, who is suffering from back pain. Mr. P.K. Deka, appearing for the respondent, submits that the mediation effort has failed. This is the matter after.
Vacation, Miller. 16th of October.
16th of
This
October.
is the matter on 16th.
of Lordship.
May it please your lordship. Lordship, I beg to make a mention of item number 12, my lord. In the seat matter, my lord, I have been appointed an amicus on behalf of the informant lordships. Lordship, the applicant and appellant had provided me copy of the petition as per
Okay.
lordship's directions. However, my lord, the registry had provided me with the paper book only yesterday, my lord. So a reasonable time may be granted, my lord.
My lord, can it be before vacation, any day other than 11 September, my lordship, before vacation?
It is all right, my lord. That may be.
Okay, right. Mr.
D.K. Boydoman.
D.K. Boydia, learned amicus curiae for the respondent number 2. Praise for time.
My lord.
The same not being objected to by the counsel for the applicant appellant. List the matter for admission hearing on 15th.
My lord, hearing day will be better, my lordship, because there's an IA for 16.
We can have the hearing now also. Section 4 POCSO.
Yes, my lordship, but still since. Lord,
In a hurry, we can do it now also.
I'll be on 15 or 16.
Give it.
15. Obliged, my lord.
Deeply obliged, my lord.
I beg to mention item number 11, madam.
11.
11.
Yes.
10 and 11 for the take matter, madam. Then maybe after 3 weeks, madam, we have some difficulties.
Here for the
And for the
appellant. Who is for the
Yeah, 11.
For 10, my lordship.
here for 10? Here for whom?
I'm for 10, I'm appearing for Vishal Guru, applicant.
For the applicant. Yes, well, what about the government? Where is the written objection? To the IA under 430.
My lordship, there is no IA. in
There is a IA 787 of 2024.
In
Item 10 it is there.
In 10, I don't have IA.
You have a IA. It is a 787 of 2024 is there.
10 of 5. Lordship will file.
You don't even know your own case. This,
After vacation.
and I think the paper book has to be made also.
My lordship, my
Okay, right. Miss A. Pigam submits that. Submits that she would be filing written objection to the application under section 430 within 4 weeks. As the paper book, as the TCR has arrived, they just need to prepare the paper book. Item 10 and 11.
Public.
This is the matter of the book.
Public.
May I please, your lordship? I beg to mention item number 8, lordship. With
Yes.
the consent of the other side,
Okay, you have
Maybe-
whom, madam? You have for whom?
I'm appearing on behalf of Mr. D. Medi, lordship, for the appellant.
Okay, right. Adjournment prayer has been made on behalf of Mr. D. Medi, Learned Counsel for the appellant, which is not objected to by the additional PP. This is the matter after
After 1 week, lordship.
after it.
Wait, this is your lordship. Lordship, I beg to mention item 28 of the daily list.
28.
Can the matter kindly be adjourned?
Why adjourn?
Lordship, my senior cannot be here due to personal difficulties.
What personal difficulty? Which court is he in?
Missing, code number 8.
Code number 8. What personal difficulty does he have? Yes,
Actually, paper book is also not available.
paper book is not available. How come? Give me item 28. It's a heroin 21C matter. Correct? Paper book served upon Miss S. Jahan, learned additional PP. 6/2/24.
We took it up on some article.
On the request for adjournment made on behalf of the appellant's counsel, which is not objected to by the learned additional PP, Miss B. Buyan.
I'll get it to her.
This is a matter after?
After vacation.
After vacation, why? This is the matter after week. This is the matter after 2 weeks.
Like,
Why do you want to adjourn all the matters? We need to hear.
Lordship, regarding item number 11, Lordship, objection already filed, Lordship.
Item 11, okay,
11.
item 11,
Lordship.
no need, no.
Lordship, item number 21.
Item 10, you've got to file anyway. Yes,
Lordship, item number 21.
21 years.
My senior is out of station
Huh?
for the another matter.
Madam, we are not going to be able to do any cases this way. Out here, a written objection has been filed also. Okay, right. On the request for adjournment made by Mr.
P. Madhunda,
on behalf of Mr. P. Majumdar, list the matter after
1 week.
the 1 week. It is noticed that written objection has been filed to the application for suspension of the sentence.
Paper book is also ready.
Huh?
Paper book is available. Uday MS.
So paper book has been made or not?
We received it.
That they want adjournment. After a week, list the matter. Yes,
Item number 23, I'd like to mention that I have filed a written submission which has not been brought on record. So,
no, we'll hear you. We'll hear, how can you appear?
yeah, please,
It's petitioner in person.
petitioner.
He's not the petitioner in person. He's the petitioner appearing for the petitioner.
Yes.
He's a person appearing for the petitioner. He's not even a lawyer. So that way, if we allow cases like him, all of you all are going to be out of job.
Yes. True,
No,
yeah.
I had- Wanted to brought it on in records.
Bring it on record. We'll hear you. Be ready. We're going to dispose of the matter.
See, this is appealed by the department under section 268 of the Income Tax Act.
There is the actual question of law has not been framed.
No, Lordship, in this case, already initially noticed.
Okay, this is under what? Okay, this is income tax.
Income tax. Lordship, what happened, notice was issued, but nobody appeared. Therefore, we were directed to publish a notice in newspaper. In spite of that, Lordship, nobody appeared. Lordship, here what happened, assessment order was passed by the assessing officer. Therefore, that was sent for revision under section 263. That order was challenged before the tribunal. In the meantime, the second
Challenge before the tribunal by whom?
by the SSC.
By the SST.
Lordship, that the 263 order.
Ah.
Then thereafter, Lordship, the assessment was made. Lordship, page 25. That was not challenged. So question number 1 and 4.
No. Just the
Lordship,
assessment was made.
yes, assessment.
Assessment challenged by the SSC.
No, Lordship, assessment was made. Thereafter, the assessing officer sent the matter for revision before the authority under section 263.
Okay.
That was made. Then, Lordship, that order was challenged before the tribunal. In the meantime, second
Challenge before the tribunal by the SSC.
SSC law.
Ah.
And the
And tribunal in favor of the SSC. made
yes,
an
we hold
order.
that there is no ground for challenge under 263 as the ingredients of the 26 are not appealed. Lordship, in the meantime, second assessment order was passed. That was not put under challenge. So we come before this honorable court, challenging the order by the tribunal on two counts.
Is it not under challenge?
Lordship,
A second assessment order was
that,
passed
that was not under challenge by the, put under challenge by
by
the.
the SSC.
Yes, Lord.
Then,
The Lordship, in the meantime,
no, the second assessment order was passed after the after the
two,
income tax what
three-
tribunal had passed the order.
no, Lordship,
Prior to
before
that.
Lordship, it is page 27. It was passed on 30/8/2019.
So you give us the date, no? How you cannot put one after the other. I mean, you have to come chronologically.
Lordship, the first order of assessment is at page 15.
Page 15.
Lordship,
Dated
Lordship, it is dated.
30, 12, 16.
to 16.
So what does it say?
Lordship, it says that that the SSC has not disclosed the investment of two companies. But that order was
Where
erroneous.
has it said that?
Lordship, it is there. Page 19, Lordship. But in view of the Lordship assessing officer, the order was not.
Let us see where it is. Let us try to understand.
Page
You see,
19.
You may be knowing everything by heart.
No, Lordship.
For us, to we have got to understand.
Page 19, Lordship.
Yes,
Paragraph 8.
yes.
On 26/12/2016 and 28/16, the authorized representative stated that he has not received any information by SSC company and he has nothing to comment at the point of time. He expressed that he is unable to give explanation before 30/11/12/2016. In the meantime, a letter from ex-director Messrs. Mehdi Bimari Private Limited and Messrs. Image Commercials Private Limited was received stating that the new director of the company are not aware of the transaction that has been wrong in given wrong information. He is pertinent to mention that no mention was information was requisitioned from all directors. Moreover, there is no legal authority of the all director to speak about the affairs of Mehdi and Bhimari Private Limited and Mr. Image Commercials Private Limited. Had the ex-director were given so aggrieved by the reply and information provided by the new directors, they would have taken up the case and the cases with new directors who were legally entitled to control and manage the affairs of the company at present, and they are in possession of all details of these companies. Therefore, the information provided by ex-directors does not add any credibility or eventually value and cannot be relied upon. The information therefore not taken cognizance of and hereby rejected. The SSC company has been given enough and reasonable opportunity to provide explanation, but failed to provide any explanation. The burden was on the SSC company.
Provide explanation with regard to what?
Lordship, with regard to investment by the two companies.
So to the two companies, to the SSC company.
Yes, Lord.
And the SSC company failed to give this information
Information,
according to the
yes.
income tax.
Because they saw in their return about the investment made by the two companies. So they failed to give any information, then the assessing officer added this amount in the assessment order. But Lordship, that order was not, that was erroneous order against the interest of the revenue. So matter was sent to the commissioner under section 263 for revision. And the order is page 25.
The
of-
commissioner's order is in your favor.
Yes, because they directed the SSC to revisit the entire exercise and pass the press order. That this order was put under challenge by the SSC. And on 30/8/2019, Lordship, the press assessment order was passed. That was not put under challenge by the SSC.
Prior to disposal of the appeal by the tribunal.
Yes, in the meantime, the SSC has disposed of the appeal in favor of the SSC, holding that the 263 order is erroneous.
And what did it say about the subsequent assessment made?
No, Lordship, it was not put under challenge, no.
Was it brought to the notice of the
No.
tribunal?
Probably not.
Probably not. Then why will they pass any order on the basis of the second?
But even the Lordship 263
on the
order,
second assessment.
263, Lordship may come to 263. Lordship.
No, I fail to understand. You're basically saying that the order of the tribunal with regard to the first assessment is wrong.
No, Lordship, the order passed by PCIT under section 263 was put under challenge before the tribunal.
Correct.
The tribunal held that the
And
order,
during the pendency of that appeal,
yes, Lordship, the fresh assessment order was passed
the
by the
assessment order was passed by
Passed
the
by-
assessing officer.
assessing officer.
Now, so that has attained finality. Has it on the same issue or on
On the
different-
same issue.
same issue?
Yes, Lord.
So that issue that was before the tribunal now has become infructuous.
No, Lordship, before the tribunal, it was the order under 263 was put under challenge. That the whether the.
What is the issue? Is the issue with regard to 263 and the issue with regard to the second assessment made, was it the same issue?
Yes, Lord, no. Because
Yes,
Lordship
no.
263,
Ah.
the authority has the power to revisit the assessment order on 2 counts. Revision of order prejudicial to the revenue. So in the opinion of the PCIT, the order passed by.
No, you just tell me one thing, you see. The second assessment, that has to go again, you can always make a challenge, that can be challenged before the commissioner,
Yes,
correct? So that is a different issue altogether.
that is different issue.
Then why you bring that up?
No,
Why
Lordship,
you always harping on that second
No.
assessment made,
no, Lordship.
not being challenged?
260, this is our substantive question of law to be decided by your Lordship. Whether,
Substantial question of law has to be decided, but the issue is that the first assessment order
Lordship,
is this, which is this 33rd, 2016,
16.
correct?
yes,
Now, this was put to challenge by you before the principal commissioner of
That-
income tax.
that was sent to the PCIT. for
Okay, that
revision.
was sent by this assessing
Yes,
officer.
Yes,
Now, where is the decision of the PCIT?
your Lordship, page 25.
Page 25.
Merit law.
PCIT dated
Your Lordship, the order dated
21
21/2/2009.
21 to 2009.
Lordship,
Now, what is the decision?
yes, this it starts from page 25.
Yes, and where is the operative portion?
Lordship, page, next page. Paragraph 4 onward. Lord. Merit law.
Okay,
The SEC has also relied on various case laws to claim that the assessment made on the basis of materials before the AO, accepting the certain facts, claim cannot be reopened as it cannot be held as erroneous or prejudicial to the interest of the revenue. Firstly, the claim of the SEC that the order accepted by the investment of Messrs Topaz Solar Private Limited and Trilok Vincom Private Limited is genuine is factually incorrect. As pointed out in the above paragraph. Secondly, there is adverse evidence against the SEC in the denial by these companies of having made any investment in the share capital of the SEC company. The evidence needed to be confronted to the SEC that the claim of the SEC remain in the light of the new fact that has emerged and the facts and evidence that SEC may like to submit further in its support. This would also take care of the grievance of the SEC that it has no knowledge of the evidence against the SEC. Paragraph 5. The scope of this proceeding under section 263 in the present case is merely to examine the evidence now emerging with the inference to the claim of genuineness of the investment in share capital of the SEC company made by Topaz Solar so and so. There is no other issue. Certainly, the SEC cannot have any legitimate objection to the opportunity so provided to the present case before the AO. Accordingly, the assessment order dated 30/12/2016 passed under section 143(3) that with 147 is set aside to the extent of examining the genuineness of the alleged investment in the share capital of the SEC company claimed to be made by Topaz and Tilok Binacom Private Limited shall confront the evidence to the SEC that the SEC shall file reply within 30 days of receiving the evidence from AO and the assessing officer shall pass the revised order after considering the reply evidence of the SEC and any other inquiry that may be considered necessary. The entire exercise shall be completed within 90 days. This was the order in under 263. That order was put under challenge before the tribunal also, on the ground that there is no loss to the authority and
No, how does this order prejudice you?
no,
At
Lordship,
page 26, accordingly, this one is set aside.
it is not
To the
prejudice to us.
extent of examining the genuineness of the evidence.
Yes, Lordship. Transaction with the two companies that has been mentioned.
That's the- oh, chair, that's a bit-
The SSC put.
Okay, so now this order was passed. So
Yes.
this order, there's no prejudice caused to you,
Yes, it is not prejudice.
not prejudice. Now subsequent to this order, a fresh assessment has been made.
Yes, page 27.
And what does it say?
Lordship, page 28.
Yes.
Paragraph 6.
Yeah.
A commission under section 131 1D of the Income Tax Act was issued to the Principal Director of Income Tax, Calcutta, to verify the genuineness of the said transaction with Mr. Topaz Solar Private Limited and Mr. Tilok Vencom Private Limited with the SSC company during the previous year relevant to the assessment year 2012-13. In reply to the said communication, TIC investigation, Calcutta, in his communication dated so has submitted to the SEC, Mr. Topaz Solar Private Limited and Tilok Vencom Limited has submitted a written explanation stating that the company is engaged.
Well, let's go to the operative portion. No point reading all.
Next page. Paragraph 8.
Where is its finding?
Yes, Lordship. Lordship, finding is paragraph 7, Lordship.
What does it say? Let's read out.
CC did not comply with the notice issued on 11/4/2019 and on so and so. A SOGOS notice was issued to the SEC requiring to SOGOS to why the transaction in share premium with Mr. Topaz and Mr. Tilok Vencom Limited during the previous year relevant to the assessment.
In para 6 only, in the page 28 bottom, I think.
Yes, Lord.
The information provided by the directors of the company conclusively prove that the SST company has not entered into any transaction with Transfer and Transfer Limited. Herein relevant to this. That is finding.
And Lordship, ultimately paragraph 8, the amount with respect to the investment made by these two companies was added to the assessment year.
Should not be termed as bogus transaction. Where is this eligible copy of this page 29? Some of the words cannot be read.
The paragraph 8 is whereby the rupees 26 crore 65 lakhs was added to the assessment.
thereafter, this second assessment was challenged.
It was not challenged.
I mean, it was sent to the, it was sent to what?
Lordship, the order was passed.
Ah.
In the meantime, they approached the tribunal. Tribunal held that the order passed under 263 is not because it was not prejudicial to the
No,
interest of
no,
the.
no, 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 no.
income
No, you
tax.
see now, thereafter, this order at page 27,
Lordship,
is assessment order,
the second assessment.
the
order,
second assessment order,
The 263 order was passed.
that is for, that says that so there has to be a tax on the income,
Yes,
so
Lord.
that 13 crores, 40 lakh, correct?
Yeah, 13, no, Lordship, page 29, Lord.
Yes. 13 crores, 40 lakh.
13
The
crore,
total
40
income
lakhs,
was 26.
so and so, Lordship.
So tax has to be
Yes,
collected on this 26.
that was the assessment order was passed. Against the SSC.
Then what has happened after
Lordship,
that?
that they challenged order 263 of the tribunal with the ground that the order was not prejudicial to the interest of the revenue.
No, no, they challenge which order?
That 263 order, page 25. Lordship, come to page 30.
Okay, they challenge the first order.
No, Lordship, they challenged the order passed under 263.
They challenge.
Yes,
Okay,
sir.
the earlier one was your challenge.
Yes. It was the inter-department communication because under 263 power vested with the assessing officer to send the assessment order to the PCIT for revision law.
So they also challenge. But then
Lordship,
this earlier one was PCIT had already taken a decision.
yes, PCIT passed order under 263 that the earlier assessment order is prejudicial to the interest of the revenue.
263. They 263, they passed an order on 21 to 2019.
19 law. That is put under challenge by the SSC before the tribunal. Page 30. law.
Okay, in this page 30,
Yes,
it's a page of the PCIT.
yes, sir.
So now the basis for this order of 58/2019 has been put to challenge before the tribunal. And the tribunal has held that
That the order passed by the PCIT under 263 is not prejudicial to the interest of the revenue, so it is not sustainable.
then it is, no. So the tribunal held that the PCIT order
Or is not.
is not
sustainable.
prejudicial to anybody.
Yes, that is the finding of the tribunal.
Then why are you here?
Now, we challenge this order that this is the order passed by the PCIT is proper order. And on the basis of that order, Lordship,
No, you see, this tribunal, the SEC challenged
yes,
the PCIT order before the
tribunal,
tribunal.
yes, Lord.
Tribunal has held what? Let us see what is the
Lordship.
exact words used.
Yes, Lordship. Lordship, page, there is no paragraph 6 is a very
So
long,
the PCIT order has been set aside.
it was set aside by the tribunal.
Correct, that's what I'm saying.
Yes,
You're
we are-
saying there is no prejudice caused. It was caused, that's why.
No, Lordship, against the first order of the assessment order that was sent to the PCIT for division under section 263.
Correct,
Then we are no prejudice to that order.
correct,
That order was challenged by the SEC before the tribunal.
correct.
And in the meantime, Lordship.
In the meantime, the second assessment has been made on the basis of the 263.
Yes, Lord.
Correct,
Now, Lord, tribunal held that the order passed by the PCA
is wrong.
is not prejudicial to the interest of the revenue, so it is not sustainable in law. That is the finding
It's
of the
not
tribunal.
prejudicial.
Yes, that is the finding of the tribunal. Lord.
Where?
Lordship, page 36.
Yes,
Eighth line from bottom. Lordship. We also, Lordship, got.
yes.
We also note that this case is no case sum of money was transferred to the SSC company for allotment of shares. Instead of allotment of shares, the SSC company was in lieu of the shares held by the share subscribing company, which fact has not been reverted contraband by the learned CIDTR or learned PCIT. Therefore, the impugned action of the learned PCIT cannot be countenanced because the order of the AO would not have been found to be erroneous in facts and circumstances of the case as discussed, as well as since the AO has made the inquiry as discussed and therefore the inference which cannot be termed as unsustainable in law. Therefore, the SSC succeed because the impugn order of the PCIT.
So where does it say the word? There's no word prejudice.
Lordship, in
Don't make up words.
Lordship,
It
it
is
is-
not there in the order.
Lordship, it is made, Lordship, in the discussion it has been made. That it is not erroneous, and so
You see, what basically falls from this order is that it has resurrected the first assessment order. The
yes,
first assessment
Lordship,
order has been upheld, basically.
yes, Lordship, indirectly we can say it. But
How
Lordship,
are you agreed?
no, we are agreed because the PCI order is proper, because it was passed under Rule 63. Properly it was passed. Because the order was.
You have not put a challenge to the earlier assessment order.
Lordship, because under section, Lordship, please to see section 263 of income tax.
Give it to the
263.
Yes.
Revision of order prejudicial to the revenue.
Yes.
The principal chief commissioner or the chief commissioner or the principal commissioner or the commissioner may call for and examine the record of any proceeding under this act. And if he considers that any order passed therein by the assessing officer or the transfer principal officer, pricing officer, as the case may be, is erroneous insofar as it is prejudicial to the interest of the revenue, he may, after giving SSC an opportunity of being heard and after making or causing to be made such inquiry as it deemed necessary, pass such order therefore as the circumstances of the case justify, including an order of enhancing or modifying the assessment order or cancelling the assessment order. 2, an order modifying the order under section 92 ACA, and 3, an order cancelling the order under section 92 CA and direct the fresh order under this section. Let's see, I've shown the finding of the PCIT. Then it was redirected to the assessing officer to pass fresh order. The PCIT pass order under section 263 that was put by challenge by the SEC. And finding of that tribunal is that the order is not erroneous and it cannot be passed under 260. So it was decided. Now, Lordship, question before Lordship.
Yes, it's in effect. So are you agreed by the first assessment order?
No,
Then?
because it was initially agreed that it was sent to the, revision was made by the
No, no,
CIT.
so how are you prejudiced? That's what I fail to understand.
We are
See,
prejudiced by the order passed by the tribunal.
no, but you see, what has, now what caused from it is that once the PCIT order has been set aside,
Not so.
the first assessment order, stands.
Not so stand, but in the meantime, fresh order was passed and we are
The
agreed.
next order has been set aside. Once the PCIT order has been set aside, the consequential order, the consequential second assessment order
Now,
stands set aside.
now Lordship, we have challenged the order passed by the tribunal before dishonorable court on the ground that, finding of the tribunal is that the order is not.
In the
is-
first assessment order, what was the decision taken by the assessing officer?
Lordship, it says that some amount was added to the SCC's income that was prejudicial to the interest of the revenue.
So, no, do you mean to say that the first assessment order was not in your favor?
No, it was partly in favor of the revenue because there was no inquiry was made by the assessing officer, so it was revised under section 263. And that 263 order was challenged by the SCC before the tribunal. And the finding of the tribunal is that the order is not prejudicial to the interest of the revenue, so it is not sustainable. For the timing, Lordship keep aside the second assessment order. Our main challenge is to the order passed by the tribunal. Page 30, Lord.
Page 30.
Yes,
Yes,
it is the order dated 28/10/2021. The first opening paragraph, this appeal is preferred by the SCC against the order of PCIT Guwahati under section 263 of Income Tax Act dated 21/12/2019 for assessment rate 2012-13. Then as the outset, the learned AR of the SCC, so assailing the decision of the PCIT contended the action of the learned PCIT to interfere with the assessment order is made in law for want of jurisdiction, since he failed to record the finding of fact that the assessment order is erroneous as well as prejudicial to the interest of the revenue, with a sine qua non for assuming jurisdiction under section 263 of the Act. Accordingly, according to him, this is a legal issue which if he found correct, then would go to the root of the jurisdiction of the PCIT to pass the impugn order. Therefore, we need to educate the same at the first instance. And ultimately, Lordship Tribunal held that the order is not sustainable because there is no finding in the order of the PCIT as to the order is the assessment order is prejudicial to the interest of the revenue.
the finding there. The information provided by. I don't know how. The same thing. They did the same. They did this, except for maybe.
But you said you're partly aggrieved in by first assessment.
Yes, Lord.
Why is that partly?
Because Lordship, in that case, Lordship, assessing officer added some amount which was not after inquiry was made. So matter was referred
Huh?
to
Added what amount?
the amount of the two companies, which have been Topaz Company and Lordship, pleased to see.
No, you see, give us the specifics. Don't give us in the general, huh? You see, where is the prejudice? Out here, when you look at page 20, it says here that the sum of rupees 13 crores 25 is hereby charged to tax.
Yes, Lordship. That amount
Then,
was,
so it's not the question of amount. The principle is that it is chargeable to tax.
yeah, because they have not submitted the required information to the assessing officer.
Huh?
They have failed to provide
Who has paid to provide?
the assessing.
Correct. Now, so what is wrong? Now,
Lordship,
this order has been resurrected.
no, Lordship, because thereafter the matter was referred to to the PCI
Agreed.
under section 263.
Correct.
Then he,
PCIT order has now been set aside.
yes, Lordship,
Then,
now,
so this order is resurrected.
no, Lordship, that's why we have filed this appeal before your Lordship with specific substantial question of law. The finding of the tribunal is not correct. The tribunal held that PCIT has no authority under, he has not come to a finding that the order is prejudicial to the interest of the revenue laws.
Huh?
The order passed by the PCIT is not prejudicial to the interest of the revenue, which mandated under section 263. And I placed four question of law, Lordship. One, in my opinion, Lordship, 1 and 4 is to be considered by your Lordship. Maybe Lordship find that there is no substantial culture from law.
Yes, Mr. Chair.
Lordship,
See, there's first assessment, there is a second assessment.
Lordship.
In both, the assessing officer has come to a finding that the respondent is liable to tax,
Yes, with respect to two companies.
whatever,
Not,
liable to tax. So the result of the first assessment and the second assessment is basically the same, maybe only on the figure.
amount figures, Lordship.
Figure.
Not,
Now, the first assessment order has been resurrected for the simple reason that the PCIT decision under 260 has been set aside by the tribunal.
yes, Lordship.
Now, on the law or the reasoning on the finding that the assessing officer has made to come to a conclusion that the respondent is liable to tax,
Not. Remains
it's
same,
the same thing.
same, but
So you cannot have any grievance with regard to that.
Lordship, but the amount is different.
So you're on the amount. Now, as per the earlier assessment and this assessment, what is the difference?
About 4 crores of rupees.
Where? Show me that.
Lordship,
How do you come to the 4 crore?
because Lordship, in earlier or in first order,
At page 20,
page 20, it is 13 crore 25 lakhs 530. But in second,
13 crores,
13 crore
25 lakh,
Lordship.
total income rounded up.
I'm sorry, Lordship, it is double. Page 29,
29,
26 crore 65.
29, 26 crores. So where is it, what do you mean? What do you mean 4 crores?
No,
This is
Lordship,
the 4 crore.
I'm sorry, it is double. And Lordship, our contention before a Lordship, that the order passed by the tribunal is not sustainable in law because the finding of the tribunal is that the PCIT's order.
Huh?
PCIT's order is not erroneous, because erroneous on the fact that he has failed to give finding that the order passed by the assessing officer is prejudicial to the interest of the SSC law. That was the finding that we have challenged before our laws. But see, under section 268A, not say please to see.
No. You see, what is the amount, transaction amount? What is the transaction amount?
Lordship, in second assessment order is written in paragraph.
No. With regard to the other companies, what is the amount of involvement?
Lordship, that was wrong in the first assessment order. This
How
one,
much is it supposed to be?
it is Lordship, in second assessment order. Lordship, paragraph 9.
Okay.
On the basis of the above discussion and facts and documents on record, the total income of the SSC is determined as under. Total income as per order 143, 147, dated 30/12/2016, 13 crore 25 lakhs. Then add income under section 68 of the discussion in para 7, 13 crore 40 lakhs. Total 26 crore 65
Now,
lakhs.
Why should you add under section 68?
Because Lordship, under section 68,
Yeah.
if that they fail to disclose. Page 60, section 68. Section 68 says that where any sum is found credited in the books of the SSC maintained for previous year and the assessing officer and SSC offers no explanation about the nature and source of thereof or the expenditure offered by him is not in the opinion of the assessing officer satisfactory, the sum credited may be charged to the income as the income of the SSC of that previous year. Section 68 says Lordship. That
So how much is to be charged? There,
Lordship, the figure is given Lordship 13 crore 40 lakhs.
So 30, because that is the transaction amount which has not been disclosed.
No, it was, yes, the sufficient explanation was given by the SEC.
Correct, so that is what 68 is.
Yes, Lord.
Now you come to page 19, let us see 19. 20.
Twenty. On the basis of discussion,
Now you see. Now you come to this figure here.
it is Lordship much below than the second.
So what is the difference?
Lordship, about half of the amount has been, there is a difference.
Yeah, you're not understanding. You're just perfunctorily going through. What is the amount of money that Topaz Solar Private Limited had given?
Yes, Lordship, it is there in paragraph.
Just come in the hall. 13, 21st in paragraph. That. So basically so now there are two figures. When you come to page 20, it is 675. 675 and 30. 6700 is Scorpio positive. So pass is 650. Now here it is 29. Outage is different. Again, outage Sherlock Wincom is there. So where this Sherlock Wincom has come also? 650 plus 660.
The page 19, last paragraph explanation is given.
See, let us see if it explains. You see the amount. Last paragraph of last sentence, last line of page 19. So
Okay.
675.
The SEC has failed to offer any,
675 and 650, correct?
and true said transaction of 675 and 650 in
650,
respect of
correct?
the share capital loss.
Now, that has been put into books by Scorpio Logistics and Warehousing and Topaz.
Yes, Lordship.
Okay. Topaz. Now, when you look at page 29,
29. Yes, Lord.
you have got figure of at para 8, 680 and 660.
Yes.
660.
That is with respect to Trilok Vincom.
This is Trilok Income and Topaz. Now Trilok Vincom's name is not here.
Lordship,
in
that's
page
why,
19.
that's why the order was sent to the PCIT for revision now under section 263. Because the assessing officer left out many things. He has considered with respect to one company only. But in subsequent order, it was with respect to two when the inquiry was made.
No. In the first assessment, there are two names already.
No, Lordship, two name, but Lordship has seen the amount. That was respect to with respect to only one company. Page 19, Lordship. The SEC has failed to offer explanation about genuineness and true nature of transaction.
You see, why you did now come to page, you come to page 20,
Lordship.
page 20. You see the last sentence of para 8. Therefore, the sum of
Some
rupees
rupees
1325.
Yes, Lordship. Hereby charge as
And
income.
that 1325 is with regard to these two companies. Now, when you come to page 29, it
Yes,
is
sir.
with regard to two different companies. One company is same, but the other company is different. And again, out it is 325.
Yes,
It
Lord.
has been rounded off to 340. That company is gone.
That,
That's what,
that,
you are not bringing the facts, Mr. Kaur.
no, Lord, it is clear from the lots of order
It's
of the
not
piece.
clear. That is, never have you made a submission during the entire half an hour that we have heard you. You have not made a mention that the company's names are different, that the companies are different. Only now we have brought it to your notice.
No, Lordship.
Now you are saying that.
No,
it
Lordship, used to say that old name and new name was there, Lordship. Paragraph,
Let us see,
paragraph
let us
20.
see, let us see. Come
Paragraph-
to, yes,
paragraph
come to page
20.
20.
Yes, Lordship.
Come to page 20.
Premium credited in books of accounts in the SEC name methods, Scorpio, Logistic and Warehousing
Yeah,
Limited.
correct. Old name is Image Comma Sol.
Como Sales.
Correct,
And
correct.
Topaz Engineering Resorts, old name Mehi Bhimana
Now-
Limited.
Now please look in page 29 and see if this Image Comma Sols and Nehi Vinime is there.
It is not there.
What are
It
you
is
talking
not-
about? That is what, these are completely different names. MS Trilok Wincom is not even reflected in page 20.
Lordship,
You don't know what you're reading. Please,
No, Lord.
you will give you chance. See, we want to understand.
Lordship,
You
definitely,
might be knowing everything.
definitely,
You
Lordship.
have not been able to communicate or give us what you want to show. You know, you're not sure of the fact. You're reading old name. I had read this old name 10 minutes ago.
All name is
And I
different.
was
Lordship.
I had looked at it.
Topaz is the new name, Lordship. The second assessment or the passing respect of the Topaz and the Lordship that
Topaz name is in both page 20 and
yes,
page
yeah,
29.
it is there, Lord.
Now you won't have Scorpio Logistics name, you will not find in
Trilok-
page 29.
Tirlog Vincom.
Trilok Wincom is not the old name or the new name of Scorpio Logistics. It is completely different. Right.
Now, Lordship, under
The
two.
prayer of Mr. STK and list the matter after 2 weeks. Please, you see, one thing, we are not very well versed.
No, Lordship,
So we want to learn. But unless you are knowing everything and are able to inform us, we cannot help you. So you please be in a position where, because we are not able to understand what you're trying to say.
no, Lordship,
It is probably our fault, but what to do? You
No,
have
Lordship.
got to try and think of a way to make us understand what you want.
definitely, Lordship. I have
Okay.
everything. Lord.
Great visa, Lordship. Lordship, in this matter, we've been freshly engaged. My Vakalatnama is not on record.
What is your name?
A. Atreya, Lordship.
Mr. A. Atreya.
Yes, sir.
Submits that has been recently engaged by the appellant. And he will be submitting Wakalatnama within
1 week, Lordship.
one. Right. In terms of the office note dated 5/8/2025. The trial court record of NDPS case number 2022 of 2022 has been received by the registry in connection with Criminal Appeal 119/2023. And that the said trial record has been tagged with Criminal Appeal 114 of 2020. Accordingly, registry to tag this appeal along with Criminal Appeal 119 of 2020.
Lordship, paper books may be.
And if Criminal Appeal 119 of 2023 and 114 of 2023 arise out of the same judgment dated
14/12/22.
14/12/2022 passed in NDPS case number 22 of 2020. The paper book, is made in Criminal Appeal 114 of 2020 shall suffice for disposing of the present appeal of. So if no paper book has been made, registry to prepare the paper. This is the matter after 4 weeks. Then in the IA, right? The written objection has been filed in this application under section 89(2) CRP. This is the matter of the court.
Right.
What happened to the other councils? They're not going to appear.
They filed a no objection, Lordship. It's on record.
Correct, sister?
Legal,
They are then a legal aid council.
there are two appellants left. One is convicted, another is six of the Foxco Act.
The present appeal has been filed against the judgment dated 18/6/2025, passed by the Court of the Additional Sessions Judge, cum Special Judge Pokso, Moregaon, in Pokso case number 132 of 2024, arising out of Mikir Beta PS case number 119 of 2024, by which the appellant has been convicted under
Page 49, last
Section-
line.
under section 6 of the POCTO Act and 87 BNSS, section 87 BNSS. Admit the appeal, call for the TCR, issue notice returnable in 4 weeks, 5 weeks, 4 weeks. Ms. A. Begum, additional PP, pays for the state. The appellant, oh, this is legally. Registered to transmit the soft copy of the appeal to the office of the PP. We shall forward the same to the OC of the concerned police station for giving a copy to the respondent number 2. This is the matter of the police.
I can forward you also, my name is not reflected, Lordship. It's a legal aid matter, I'm a legal aid counsel.
Okay, heard Mr. J. Das. This is also under section 6. This is judgment dated 6/8/22, passed by the additional session judge cum special judge Pokso, Sagar, Pokso case number 23 of 2021. Arising out of demo PS case number 66/2020. Okay, out here, he has been convicted under section 6. Only section 6, huh? The PS not. The same thing.
In this matter, I'm appearing as a legal aid counsel. It's a jail appeal.
Mr. S. Panik, learned counsel for, learned legally counsel for the appellant. This is an appeal against the impugned judgment dated 25/11/2014. Judgment 25/11/2014, passed by the Session Judge Moregaon in Sessions case number 34 of 2014, by which the appellant has been convicted under section 302 IPC. If you notice, tenable in 4 weeks. If you come accept notice on behalf of the state, they will admit the appeal, everything, or for TCR, everything to be. This is the matter. Then in the IA,
My lordship.
okay, right, with every gun, we granted 4 week time to file an objection to the application under section 430 BNS. This is the matter.
Yeah.
Paper book is, paper book has to be, right? Mr. A. Dharan, learned amicus curiae, appears for the appellate. As the TCR has arrived, registry to prepare the paper. This is the matter of the court. No one appears for the appellate. As per office note, address is not available.
Lordship, item number 7, as per my record, LCRB call for issue reminder.
Ah.
Lordship, but causeless doesn't say anything as regards to receipt of LCR.
No, it is, it is in another case. So we appoint somebody. Point number two. This is a Pokto, na?
It's not,
Is it Pokto?
no, Your Lordship.
No, okay, not required. Right. As this is a matter regarding conviction under section 302 Act. Notice deemed to be served upon the response. Next. No, go to that. Let's say, no further notice need be sent to the response. Next. In terms of, no, of the office note dated 28/5/2025 states that the case record of this is case number 173 of 2006 has already been transmitted to this court in connection with criminal appeal 469/2020. Accordingly, a registry to track this case along with criminal appeal 469 of 2020. Then that I have affected. In the event paper book has been made in respect of criminal appeal 469 of 2020. The same can also be used in relation to the present appeal, provided that the said criminal appeal 469 of 2020 arises out of the same impugned act. This is the matter after revocation. Oh, see.
May
Yeah, wait, in the IA, you're right, in the IA, you're right. No one appears for the applicant. The respondent state has filed written objection to the application under section 389.
So Lordship, otherwise this case is ready for hearing.
Item?
Already it was item 9. Listed for hearing also, just before the vacation, Lordship, summer vacation.
So
But
we-
what happened,
So we can dispose of the IA.
I am
This
not
was
pressing.
this.
I am not pressing because he had already completed 14 years. This man.
Ah.
And now that as per rule 571 of Assam Jail Manual, as it is stated by me, the appellant Lordship, his case has been already processed to the IG for remission because he had that report,
So we'll dispose of this IA then. We'll dispose of.
Lordship, that IG report may be called for
We'll
Lordship,
call it in the main appeal.
Lordship.
Okay, right. Ms. B. Sharma, learned legal aid counsel for the applicant. Submits that she is not pressing the present application for suspension of the sentence and release of the petition on bail. In view of the fact that the case of the petitioner slash appellant is under consideration for remission from having already been in judicial custody for more than 14 years. Ms. B. Buyan, assistant for PP appears for the state on considering the submission made by the counsel for the applicant, not petitioner, applicant slash appellant. The That's so. Huh. Then in the main case, you're right. Ms. B. Buyan. Miss B. Sharma, the learned legal aid counsel for the appellant, submits that the case of the petitioner for remission is under consideration with the respondent authorities in view of the appellant having been in judicial custody for more than 14 years. So we call from whom, report from whom?
As stated by the apparent lordship that he is in Madurai jail because he is a resident of there. He served 10 years in Assam. Now he is transferred to Madurai jail.
Madurai.
Yes, because he is after spending 10 years here, he was transferred under that there's a provision for transfer in humanitarian ground.
Then
So then there, according to him, the authorities of Madurai jail sent an application as because the remission has to be given by Assam because the sentence is by Assam. So it is possibly it is before the IG prison. That is what
you obtain instruction.
That-
Miss B. Buyan shall obtain instruction from the IG prison, Assam, as to whether a petition for remission has been made in favor of the appellant who is presently in Madurai Central Jail.
Madurai
or what?
Central Jail.
Central Jail or what?
Central jail.
Madurai Central Jail. After having been transferred from what is Central Jail? From Assam.
Assam.
From Assam. This is the matter when today's third. Just you
Yes.
get by the end of this month. Okay. By 24th, this is the matter of 24th.
Copy be,
A copy of this order be furnished to Ms. B. Buyan. Better to mention the thing there. Just
Yes.
mention the judgment. Just before we before directing, this is the appellant has been convicted under
Huh? 302 lordship.
page
and
70 of the
section
petition.
302 IPC by the
Station Judge Chirang Fazalka.
impugned judgment dated 20/08/2015 passed by the learned Sessions Judge Chirang Kajalgaon in Sessions case number 144 bracket Basu /2015 arising out of Basu Gaon PS case number 10 of 2011, 2001. 2000. He was a CRPF or what?
Yes.
You say appellant who was a CRPF. Was a CRPF Jawan. That will become easier then.
Okay.
May I please, Your Lordship? Lordship, I'm sorry, I missed the item number 7, Lordship. Yeah,
Lordship, in this case, Lordship, office note indicates that the notice has not been returned. Or neither ID card nor unsubscribed notice has been returned.
Out here also substantial question of law is required.
Yes, Lordship, it is, the notice was issued.
My lord, we are engaged, my lord, but due to some unavailable situation, the Vakalatana couldn't be filed. Well, in the meantime, we'll file Wakatnama
Mr.
and Estarma.
S. Sharma. Submit that he'll be appearing for the
For this.
appellant.
Yes,
In both-
sole respondent.
In both the cases,
In both the
respondents in both the cases. And submit that he'll file the Kalatnama within
within a week.
a week. This is the matter after.
But in the meantime, my lord will also need a leave because court to file preliminary objections
You file it.
after 4
This is the,
after 4 weeks.
after
We'll file Wakatnama and the matter may be listed after 4 weeks.
outer limit, 4 years, 40 years, outer limit. How much outer limit do you want?
Within 4 weeks.
This is the matter. It said this is the matter this year. This give a date this month.
Okay.
No one appears for the
Paper book is ready.
appellant. Paper book has been paid. It criminal appeal 20 or 22. This people appears for the. Okay. As no one appears on behalf. Mr. Mazumdar,
LR Mujumdar then.
Lordship, matter will fix the hearing. Lordship already provide book ready. Lordship,
we are ready now also.
today itself. Lordship.
Now means what? Now means tomorrow.
Then make fix the any other
Okay, right. On the pair of Mr. L.R. Mazumdar, this is the matter after
2 weeks. Lordship.
after 2 weeks. He submits that he has received the paper book.
Not.
Ms. B. Boyan also submits that he has received paper book. Accordingly, let's cut after 2 weeks. Cut the rest.
Online.
Heard Mr. C. Goswami, learned counsel for the applicant who submits that there is a delay of 5 days.
5 days.
In filing the appeal. Ms. B. Boyan, additional PP, submits that she has got no objection if the delay is condoned. Accordingly, the delay of 5 days condoned. Registry to list the appeal within a week. List the matter after. I is accordingly the fourth.
Public.
I mean, yeah. Let's take it up.
What is your name, madam?
Lordship, Madam, may possible for
What's your name?
K. Das Kunika.
Alright, Ms. A. Das, learned counsel for the applicant appearing on behalf of
Assembly.
Mr. S.A.M. This is an application for condonation, for condoning the delay of 12 days. In preferring the session. Ms. B. Boyan, Mr. CP, submits that she has got no objection to the same. Accordingly, the delay of 12 days condoned. Registry to list the matter within a, list the appeal within a week. I is accordingly disposed.
I'll copy, copy. Lordship, we have received a service report in this matter.
Item 22.
No, that 20. Equi Roba. Excuse me.
My lord, I came.
12 days
My lord, I came.
No, delay may be conducted, but service is also complete. We have taken steps on the victim.
on the victim. Okay, you're right. In the victim, you're right. As per the as can be seen from the report submitted by, letter submitted by the SI Vidyut Kumar Nath, Hatti Ground Police Station. notice has been served upon the informant. Accordingly, notice, just put-
Obligement.
No, any objection, madam?
Which one, my lord?
22,
You did-
7 to 9 days. 7 to 9,
Oh. 750.
no objection, right? This is an application for condoning the delay of 7 to 9 days in preparing the appeal against the judgment by which the applicant appellant has been sentenced, has been convicted and sentenced under section 302 IG. Please be clear. Adequate speaking, nothing that there is no objection to the delay being condoned. Accordingly, the delay of 7 to 9 days condoned. The registry to raise the appeal within a week. This the I accordingly dispose.
Lordship, in that Paul matter, your lordship made a query as regards, because the accused person had completed 17 years, few months.
Ha.
Yes, lordship.
Yes.
Lordship, Jitendra Singh Jasmine, your lordship may kind of have a note. It's reported in 2013, 13 SCC,
2013,
13 SCC. 764 SCR.
yes,
That would be.
yes. Just print out, 2 copies. If it's not,
Where are 85 to 90?
how many pages?
Oh.
Very long. I
90.
take out the relevant part.
Lordship, 85 to 90, sir. Sir. Jitendra Singh versus State of UP. Thirteen SCC 7 SCR. Yes.
764.
Yes.
2013, 13 SCC, 764.
Yes. SCR 764.
Oh, SCR.
Yes. So, no? 13 at SCR 764. Paisa? The Manupatra ito pa. Jitendra Singh versus State of UP. Oh, mail ko din. Crimes of person. Decided on 10/7/2013. Criminal Appeal 763 of 2003. Era mail ko dito. This
This is what? Chat GPT or something?
No. I've used a Gmail, my. Is it? Oh. Is it? I have. 4282.ghe. Yes. Okay. Need to body. Yeah. Wi-Fi na more later mobile. First. Yes, got two.
Yes. Yeah, submitted an affidavit.
Yeah, it has been annexed, madam. They said they have annexed it there in the case. Yeah. Yeah, main petition.
This must be the one. They've got it.
Your lordship, yeah. Proceed.
Who is for the other side? You go quick. You can say advocate that. You see, what has happened here? It's for all the lawyers here, basically. That this is a MS Sai Nath trader. They have now they have filed a case against the state of Assam, the Commission of Taxes, basically a taxation matter. Now the person in front of us has nothing to do with the petitioner. He is not the petitioner in person. He is not the. It is a proprietary firm, Sainath Trader. They have made him the power of attorney holder, and he wants to appear on their behalf in this. He is not a lawyer. So the issue is whether whether he should be allowed to appear on behalf of the trader. Now, he has given an affidavit giving reasons of why he should be allowed. Now, having said that, the question is whether we can allow A, B, and C, A, B, C, D to appear in the court on behalf of any person who that petitioner might constitute or appoint as his power of attorney. In that case, your jobs are on the line.
No, my lord.
This is
No,
specific.
no, just a minute. I'm not talking to you. I'm addressing everyone because you see, it's going to, it can affect them directly also. Now, why should it be limited to this case, supposing we allow your petition? Why should it not go into criminal cases also? Family matter is also divorce proceeding. So now, I don't know, we are going to go into this issue. And of course, he has relied upon Order 3, Rule 1 CPC, which is any appearance, application, or act in court may be made by a party person, by his recognized agent, or by a pleader. Then Order 3, Rule 2A CPC, recognized agents include persons holding powers of attorney, authorizing them to make such appearances, application, and act on behalf of such parties. Section 32 of the Advocates Act. Now, whether all this will entitle a person to appear in court on behalf of the petitioner. Keep it in mind, he is not the petitioner. He wants to act on behalf of the petitioner. So so maybe after listening to him, we might have to call the bar station also and ask them their views, provided we are satisfied with what he says. So we want you all to listen also and maybe give us some input. Because if we say yes, tomorrow 1,000 others will come and say that they've been appointed by their neighbors, by their cousin brothers, by their uncle and aunties, everyone to appear.
Ego is appearing in this matter.
No?
He's on legs.
He's on.
Legs matter.
Legs.
Having a matter in another court.
So now, okay. So we will wait for some time. Okay. Maybe in the meantime, if the bar station wants to, or they'll want to make some submission, we are open to hearing everyone. Because if we allow, and tomorrow, Miss A Begum, you got to look for a job outside the government. They will say that they will now appear for the government. Supposing government says we are going to appoint, we're going to give the power of attorney to A, B, and C. So 3 sections 32 Advocate Act. And then have you given a copy of the affidavit to the other side?
Yes.
To whom did you give? Mr. Gogoi. So there are some judgments he has pronounced, of course. I don't know whether this has got anything to do with this, but
It is my word.
correct. Except no, where we need their expertise. With the lawyer and in that case we allow, but not as a general practice. So out here the proprietor, as per para 3, is medically unfit. Correct?
Yes.
That's why he has engaged you.
Yes, ma'am.
Then why can't he engage a lawyer?
Your
Are
Lordship,
you
I have
taking any remuneration?
No.
Free of cost.
No, I have been representing the proprietor in front of the commercial tax official since 2019. And I'm not seeking any blanket approval to practice law, only specific to this revision petition under section 81 of the AVAT Act.
No,
And,
but then
my lord, there is a precedent specific to our case also, my lord. I want to share you the copy of the precedent.
Sure.
My lord, third precedent, that's Harishankar Rastogi versus Giridhari Sharma, is the same and the similar case what we are hearing for. If you can please allow me to read the act, the practice and process of rule 1, read with order R2.
Which para, which page?
First page, page 1.
Yes.
Harishankar Rastogi and Giridhari Sharma. This is a very specific and the similar
No,
case.
no, you have given us MS Shankar Finance.
No. That's the first one. Third, I have flagged this as third.
Oh, okay. Yes.
There's a judgment by a single bench,
Single bench, where?
Supreme Court.
Supreme Court single bench?
Yes,
Okay.
it's a single bench.
Yes.
So practice and procedure, rule number 1, read with order 1, R2, 1A and B of the Supreme Court rules, 1966, Advocate Act 1961, Section 2A, 2931, and Criminal Procedure Code 1973, Section 2Q, 302, 303, 304, Civil Procedure Code Act 5, 1908, Section 2 within bracket 1.5. Read with order 4, right to be represented by any person, another person who is not an advocate, whether and if so, when permissible, meaning of the provided the court may, if for a special reason it thinks desirable to give permission for other person to.
Provided the court may.
Yeah, I'm seeking that leave only, my lord. I have never said that I'm eligible. In the last hearing also, I said it's the discretion of the honorable court. And all the 3 orders, everywhere it's maintained, it is up to the court's discretion to allow me to appear. My lord, in the second page, the petitioner appeared in person and sought permission to.
Please come to paragraph 1.
Yeah. Yes, ma'am.
L.
Yeah.
Paragraph 1, please read.
Pardon, sir?
Please read paragraph 1.
A private person who is not an advocate has no right to barge into the court and claim to argue for a party.
So, a private person who is not an advocate
Yes.
has no right
Yes.
to barge into a court
Yes.
and claim to argue for a party.
Yes. I agree, sir. But even in same order, last paragraph, the final.
What has happened was you had wanted to argue, but we did not allow you. That's why we had fixed this day.
Yes. Yes, ma'am.
So your first sentence out there is read the second line also. Read the second sentence.
He must get a prior permission of the court for which the motion must come from the party.
Where is the motion from the party? The very judgment that you're relying upon is against you.
So we have applied for and they have,
Who has applied?
no, I applied for the I.
You are not the party. You are not the party.
I agreed, sir. I'm agreeing to it that the petitioner is incapable. Because of that, I'm seeking court's leave.
If he is incapable,
Yes,
then how are you appearing for him? How did he sign something?
no, he has given a power of attorney.
How did he? So that is what. How did he give a power of attorney? He signed it or not?
Yeah, he signed it.
He signed. So, for a motion to come to this court, it only needs a signature, nothing else. If your client would have signed the power of attorney, he could have easily signed a motion for allowing you to appear on his behalf. Power of attorney is not a motion. And keeping the fact that this is a normal case right now. It's not a question of where we need expert advice, where the councils might not be very much aware, keeping the intricacies of some practical issues. Say environment, the soil, topography, and those things. I don't think that there's any ground made out right now, and there's no motion also to allow you to appeal.
So I have applied for that, as per my, as per my knowledge, I'm wrong, sir. So it has not come to the motion, it has come directly for orders.
No.
IA has come directly for orders.
I has come for orders. There is no motion on the part of the on the part of the person you want to represent.
Give me an opportunity, sir, so that you can come back.
But why? Why should we allow you?
Because, sir,
What special knowledge is it that you have that the lawyers don't have?
no, not because of that, sir. It's the trust which my friend have shown on me since 2019. Have been presenting him in front of the not seeking a blanket approved leave also, my lord, only specific to this case.
Any other, what is your other submission in support of your claim to represent this person? Any other thing?
These are, I have already submitted, and
There are some judgments you have brought out.
yeah, and in Advocates Act, my lord, it has been specifically section 32 of Advocate Act, it's specific that notwithstanding anything contained in this chapter, any court, authority, or person may permit any person not enrolled as an advocate to appear before it any particular case. The provision empowers this honorable court with discretion to
So that now they have given us two reasons of why you should be allowed to represent. Number one is the medical problem of that person. Number two is trust.
yes,
So he trusts only you.
my lord.
Supposing he has to go for medical advice. Then
No, then he has to go. I cannot go as a power of attorney, and it is there written in everywhere that I cannot be deposed on his behalf for his actions. And here I'm
you're working as what are you?
I'm a businessman, and
You're a businessman.
yeah, I'm a businessman. We work together.
Okay.
When we were working, we work together. And because of
And this matter pertains to taxation.
yes, my lord.
And so you are the expert in taxation.
No, I'm not the expert. I have been representing the department, and I'm well versed with the provisions and the fact of the case.
You're representing who?
Mr. Sainath Traders. And it has been recorded on orders.
Reminds me of that two businessmen speaking to one another. One was telling the other, why do you have to hire lawyers? They are so costly. You see the office full of books. You go and buy those books that the lawyers have. Then the other businessman, his friend, told him, but the problem is they know which page to turn to. I don't know. I doubt you'll know which page to turn to. Anyway. Yes, Mr. Gogoi. He wants to represent.
From that, I leave it to your lordship, provided he has got the authority from the my lord company, that he will represent that. There will be.
My lord, he's a businessman.
My lord.
He wants to represent another businessman in a tax matter.
Lordship.
Yes.
Otherwise, my lord, yes, considering, my lord, it's a company, he can at least afford a, my lord, legal cost. That's the,
You see, you cannot take it very lightly.
No.
Because this, any order that we pass today
my lord.
can be used in future,
Lordship.
cases before a single bench also,
Well,
and outlying benches, then you're gonna have problem. So we've got to be very careful.
Lordship, in fact, my lord, on the last occasion also I submitted, my lord, there is a contempt page, a case pending, my lord, against the present petitioner, by this particular petitioner. Hearing. Initially, he appeared, subsequently, when the court objected, court number 5 vehemently objected, punishment of preventing the petitioner. Now they have engaged a counsel. The last occasion, counsel have appeared. It's not that they cannot afford or, my lord, they, that in all cases, my lord, relating to the same issue, but
Ah,
that lead part, I leave it to your lordship.
My lord, I may please be allowed to read the third President Harishankar Rastogi and Giridhari Sharma, the last.
Huh?
Harishankar Rastogi and Giridhari Sharma,
ah,
the President's last paragraph and the final verdict.
yes,
Having regard to the conspectus of the consideration, I hold that private person who is not an advocate has no right to barge into the court and claim to argue for the party. He must get a prior permission of the court, for which motion must come from the party himself. It is open to the court to grant or withhold permission in its discretion. In fact, the court may, even after grant of permission, withdraw it half through if the representative proves himself reprehensible. The antecedents, the relationship, and the reason of requisitioning the services of the private person and a variety of other circumstances must be gathered before grant or refusal of permission. In the present case, I have noticed that petitioner and his friend, who is to representative, came along with a mutual confidence. The party somehow has not shown sufficient confidence in the advocates he has came by. This bodes ill for him. I should have suspected the association of the private person as having similar implication of exploitation of the glueless party, but suspicion by itself should not be the basis of a conclusion. Therefore, I think it's right to give the party who appears to be unable to represent his own case an opportunity.
Tell us why you should be considered over the other lawyers. What is so special about you?
Sir, it is up to.
What is so special about it? What is so special about your case?
My lord, I'm making my submissions. It is up to the honorable.
No, that's why we're asking you.
Yeah. Because
You
I have
see,
been
we are
represented-
making a
yes.
submission, but we have a right to ask questions. Okay,
Yes.
so when don't answer our questions by answering that you have got a right to make submission. You have got the right to make submission, but we cannot. But we have got a right to know as to why we should answer all your submissions.
My lord, in fact, my lord, there is not a single ground, my lord, cited as to why he should represent the company.
Only thing is that his friend is medically ill. And now he said that he's got trust.
My lord, I want to place this orders of the commercial tax where
They
it
are
can
even
happen.
appear, my lord,
Huh?
before the-
Tax, they can do what they like.
the retail authority, they can-
This court is different. What about the other judgments? What are you relying in this Shankar and all? Nothing.
Yeah. Shankar Finance it is about the propriety concern has no separate legal existence.
That is
Yeah.
the law point.
Yeah, and PC Mathai and versus district judge and a power of attorney may appear and act under order 3 of the CPC. Right to plead requires court's leave.
That's all.
Yes, my lord, these are the 3 precedents. Whereby a private party or a petition, authorized person or a power of attorney who can appear before a court, but with court's leave. That is my humble submission. Until unless this honorable court allows me, I cannot argue or appeal.
Right. You're giving us something.
Madam, there is one judgment, madam, my colleague has, madam, placed it. It has been passed by the honorable court. With AIR 1992 Guwahati 54. In a similar case, it was rejected. A similar 54, page 50. That way division was done.
Right. Heard Mr. Sanjay Kumar Sarkar appearing on behalf of the firm MS Nath Trader, whose sole proprietor is Mr. Sanjay Kumar Sarkar. Next slide. Mr. Sanjay Kumar Sarkar, Mr.
Proprietor is Mr. Sanjay Kumar.
and Mr. No, wait, what is your name?
My name is Sanjay Kumar Sarkar and my proprietor's name is Sanjay Kumar, only Sanjay Kumar.
Huh? No, what is his name? Him and the proprietor name? Okay, he's only Sanjay Kumar. Is it?
Yes.
Okay, Sanjay Kumar, huh? Proprietor Sanjay Kumar. Good stuff. Also heard Mr. B. Gogoi, learned additional AG or what? Additional AG. The present application is to grant leave to Mr. Sanjay Kumar Sarkar to appear and make submission as the authorized representative of MS Nath Traders and Sanjay Kumar and proprietor Sanjay Kumar. In the revision petition, which has been filed, challenging the impugned final order dated 20/06/2025, passed by the respondent number 3, bracket additional commissioner of taxes. The application made under section 151 CPC, read with article 227 of the Constitution. 227. How is 227 applicable?
It will be revisional. Jurisdiction.
Okay.
Provision of the.
Okay, revisional. Okay, read with 227. Read with article 227 of the Constitution. Has been made on the ground that the sole proprietor, Mr. Sanjay Kumar, is suffering from serious cardiac ailment, including angioplasty, and continues to undergo periodic medical treatment. Due to his fragile health and acute financial hardship, the proprietor, the sole proprietor is unable to engage a legal counsel and has authorized the applicant, comma, to file and plead the revision application before this. Mr. Sanjay Kumar Sharma. Huh? He's Sanjay Kumar Sharma. Mr.
Sarkar.
Sanjay Kumar Sharma appearing on behalf of Mr. Sanjay Kumar.
My lord, my name is Sanjay Kumar.
Huh?
My name is Sanjay Kumar Sarkar.
Sarkar, okay. Sanjay Kumar Sarkar appearing on behalf of Mr. Sanjay Kumar. Submits that give me CPC. That in terms of Order 3, Rule 1 and Rule 2, bracket A, CPC, the comma he can appear on behalf of the applicant, comma, even though he is not an advocate in terms of the Advocates Act 1960. He also submits that in terms of Section 32 of the Advocates Act 1961, this court can authorize this court can permit him to appear on behalf of the applicant. He also submits that in support of his submission, he has relied upon the judgment of the Supreme Court in TC Mathai versus District and Session Judge, 1999, PSCC 614. Mr. Sanjay Kumar Sarkar has also relied upon the judgment of the Supreme Court. Supreme Court in the case of Hari Shankar Rastogi versus Girdhari Sharma, 1978, 2 SEC 165, wherein it has been held that though a non-advocate has no right to audience, the court has inherent jurisdiction to permit such appearance in the interest of the next part. The person, no, don't say the person, you just say Mr. Sanjay Kumar Sharma appearing on behalf of the applicant submits that the applicant has undergone angioplasty. Submits that the sole proprietor has undergone angioplasty and is medically unfit to appear in the further. Mr. Sanjay Kumar Sharma has consistently represented the petitioner before the Commercial Tax Department since 2020. And as such, he is fully conversant with the facts of the case. He accordingly prays that he should be allowed to represent the applicant / sole proprietor. Next. Mr. P. Roy, the learned additional lady on the other hand. Where is your key? Your key? Yeah. Submit that on the reading of section 29 and 33 of the Advocates Act 1961. Only advocates can practice law. And a person who is not an advocate cannot be allowed to practice the profession of law. However, it is open to a person who is a party to proceedings to get himself represented by a non-advocate in a particular case as is provided under section 232 of the Advocates Act, provided that permission is granted by the court in the interest of justice. After considering the varieties of factors for such non-professional representation. In this regard, he has relied upon the division bench judgment of this court in the case of Nibaran Bora versus Union of India and others, 1991, 1 GLR 41. Yeah, the Mr. P.O. accordingly submits that the application should be rejected. We have heard the learned counsel for the party. We can put a microphone for legally. If he doesn't have. How do we know that? Where is the question of money? There's no affidavit. But he'll have to show that he doesn't have money, you know. Correct. Just give me the appeal. This is the appeal. What are you challenging? What is the challenge here?
The challenge is that, my lord, the revision authority, first and foremost, this entire order is
Forget it. What is the amount involved?
is 3 crores 63 lakhs is the amount
3 crores 63 lakhs.
that they
That they're demanding from him.
no, they have add-on. They have put an add-on that amount.
They've added on.
Added on that amount. Which
3
is a-
lakhs, 3 crores
3 crores
63 lakhs.
63 lakhs is an amount. They have added that.
Added on to the
There is a difference of
to the tax payable by him.
no. That is a difference between in the income tax audit as well as the VAT audit. There's a difference on that amount. They have added a
Income
taxes.
tax audit and VAT audit.
Yes.
How much is his ITR, income tax return? This poor person. This he's a poor person, no? This applicant, not poor.
No, he never claims.
Oh, he's not a poor person. I just wanted to know. I thought we will provide him with some legal aid counsel No.
It's
He's not
not a
caught.
question of poor person.
Not a
It
question.
is basically because I have been.
Okay, no, but he's well off. He's got,
Yes.
Huh? No, it's there in the thing, it's there live streaming is there. So he's quite well off.
Yes, sir.
Okay, I'll pass complete the order later. 3 lakh 63 crores, 3.63 crores add on. Just put that, 3.63 crores add on, huh?
My lord, I'm extremely sorry for item number 22, my lord.
Huh?
I'm sorry for the item number 22, my lord.
23, yeah.
22, my lord, previous, my
We have
lord,
allowed,
I
we have
was for
allowed,
condonation of
we
delay.
have
my lord.
allowed, we have
So
allowed.
bless.
You want your name to be there?
BRS Sultan, I am legal aid counsel for the appellant.
Okay, put her
petitioner.
name. And then
I
item
am-
22, PRS Sultana appears, legal aid counsel appears for the applicant.
No, sir.
Huh? Oh, it is,
No, sir.
I think item 90.
I'm sorry, man, I was not there. No, this is a appeal, criminal appeal, man, arising out of a NIA case, NIA, man, where my bail was rejected by. Now, on earlier occasion, my lord, your lordship they had approached this court for rejection of my other bail, man.
for allowing your other bill, for cancellation.
Cancellation of the bail, that your lordship. Now, my lord, the question is, I'm paying this bail, my lord, on two grounds, my lord. Firstly, my lord, the incident is of one. So there should be only one FIR. The second FIR should not be same incident. Number one. And secondly, my lord, while filing the forwarding report before the court below in the first case, they ought to have stated there that there is another case pending against it.
Same. You have been taking it, no? So you come at 1 o'clock. Just continue the thing. Same incident.
Same incident. Now,
Number one is same incident. Number two is what?
number two is that, my lord, in the forwarding report, the earlier case, they should have informed that there is another case pending against it. They should have informed as per.
When was this case registered?
This case is registered, my lord, on 05 9 to 24, no? 9 to 24. Page 20, but 9 to 24. Huh? That is by NIA. And the other one?
Is it the same incident?
No.
Not same incident. Is it under the same police station, jurisdiction? Same police station?
Attacks are in two different.
At two different places.
Time also,
Time also different.
one is in the morning, after it's in the afternoon.
Yes, so he says one is in the morning.
Yes,
and
but
the
page, if a lordship turns to page 20 for a once, my lord. 20, my lord.
Yeah.
Below, my lord, lordship, serial number 5, my lord. Place of occurrence, my lord. Address, my lord.
Page 20.
Page 20, my lord. Serial number 5, and the last line, B, my lord, small b.
Yes.
In front of SBI More Town, about 600 meter north from More police station. This is the place of occurrence. And the other case, my lord. Other case also same, my lord. It will apply for 26. And moreover, my lord, this is the arrest memo, my lord, that was. Serial number, this is RC 05, my lord, serial number 7, my lord.
Yes, what do you want to show here?
My lord, it says, my lord, 2 persons were killed.
Too many police, yes.
Yes, now they are separating because of 2 FIR, one is 05, one is 06.
We don't know. We don't know whether it has been separated or not.
So this was the first submission, my lord. The incident is said.
They are saying that it is 2 different places.
No, that's why, my lord, I have pointed out, my lord, the last line, my lord. In
last-
front of the SBI More town.
Okay, that is for this FIR. What about the other FIR?
The FIR, my lord.
If I access point, first we come to page 19.
19.
The order passed on the FHA,
19.
page 19,
Yes.
and actual one.
NXK 1, yes.
First we can find 2 cases. First one, attack by so and so on 17/1/24 at India Reserve Battalion post Lima Hongdong, wherein be using open firearms, which led to the martyrdom of 1 rifleman. And the second one, the distance might be the same. It is attacked by some so and so at Indian Reserve post More town using open fire, which led to the martyrdom of 1 Havaldar commando and 6 personnel. There were 2 incidents. One in the morning, one in the afternoon.
Where do you get morning and afternoon? How do you differentiate?
My lord, lordship will only see
There's no
page,
time given.
page 20 and 51. Page 20, your lordship will see the time, my lord, 05, 3 hours. Day Wednesday, date 17/1/24, time 05:30 hours. This is with regard to RC 05. Now, page 51. $310, my lord. And the place of occurrence, my lord, address, my lord, and More town, about 600 meters from north from More police station. Same place.
We see 3:10 p.m.
3:10 p.m.
And this one is 5:30 hours, 053 hours. So 5:30 a.m. One is 5:30 a.m. and one is at 3:10 p.m. So there's a huge difference. 5:30 in the morning and 3:10 in the evening.
But actually, my lord, this point was also I have not raised before the court below also.
But you are raising it before us. Now it is before us.
My main contention was that, my lord, before the court below was that, my lord, I ought to have been informed that there is another case pending against. And the court below, my lord, while passing the order, my lord, lordship will kindly turn to page 59 for a once, my lord. Page 59, my lord. Last paragraph, my lord, page 59, my lord. Having heard the contention of Sri Chaudhary and on careful scanning of both cases record, it transpires that this court has been intimated about the pendency of both the cases against the accused person. Of course, not specifically against the accused. Now, by this order, my lord, they are referring to page 19, my lord, 19. Page 19, my lord. It only states, my lord, there are 2 cases, my lord, not against whom, nothing, my lord.
So, my lord, my prayer before your lordship is that, my lord, submission is before your lordship, my lord. My lord, they have failed to tell me, my lord, that another case is pending against me.
When were you arrested?
I was arrested 26, 25, 25.
524.
20525.
In this case.
In this case, I was arrested 26, my lord. 200625. Once I got the bail in the other case, as soon as I came out from the jail, my lord, from the jail gate, I was arrested, my lord, on 200625.
What is the case number here in this one? In the present
The
case?
present one is 06, my lord.
06.
RC 06.
That is page 51.
Yes, madam.
What was the basis? How far is the distance between these two places?
My
How
lord,
far is the distance between these two places?
how far is the
Distance.
distance between?
These two places of incident.
My submission will be the same place, my lord. Moria Bazaar, my lord.
Huh? Please, same.
Same.
That big. Yeah, yeah.
600 meter for.
Okay.
They had the knowledge, my lord, of the other case, my lord. So I was in the jail, my lord. They could have started a notice out there, my lord. As soon as I got bail in the other case, my lord, from the jail gate, I have been arrested.
You were granted bail when?
I was granted bail, my lord. 1806, my lord. But after submission of bail bond, my lord, I came out on 26.
Now, Lordship, I required from the IO. Total distance is taken to be some 600 meters. From the police station, it's on either side.
No, you said north.
Yes, you have made your submission just.
No, I have not completed.
No, I've heard it.
Only I'm citing, my lord, some decisions, my lord.
Wait, later. Let us get the fact.
As per the Lordship instructions that I have, Lordship, it's on either side of the investigation. And insofar as the investigation in 6 is concerned now, the Lordship will note he was initially arrested in the first place on 19/5.
You said 25?
No, in the other case.
19/5.
In the initially he was arrested on 19/5. And he was arrested from somewhere in Silchar. Now, at that point of time, Lordship is well aware, the cases from Manipur has been transferred to Assam due to the volatile situation out there. So far as the IO and other investigating officers are concerned, it is virtually impossible for them to pick up this person from More. Because these investigating officers, they are not in uniform. They cannot simply go to More and pick him up.
he was put under surveillance. As soon as he came out from Mode, he was picked up from Silchar, arrested in the other case. And thereafter his mobile phone and all were seized. And on scrutiny of the materials in the mobile phone, it has come out that he is involved in the other case as well. That is when, because these, whatever communication was there was in Tuki language. That had to be translated. That was translated. Then the IO got a permission from his SP. For the next course of action, SP directed that he arrest him immediately. Thereafter, he was arrested. This communication and the arrest, that final approval from the SP that he has to be arrested, that came on 19th.
I think,
Worship can continue at 2.
but, we've got some meetings also. After you dictation also.
Oh,
You see, one thing is that, my brother will not be here from tomorrow. So, I don't know if we'll be able to complete today, even if we have to pass the order this time. So maybe we fix it again next week.
My lord,
Otherwise, no point.
lord.
Otherwise, he's not going to be here.
let's understand.
Or next week, I'm going to have TB1. I'm going to have TB1. Yeah. I think we'll have it after next week, because next week I'll be taking up DB1 matters also.
Any day, justice for me.
No, he'll be here next week, but we're going to be taking up DB1.
Oh.
Probably Chief will not be here next week. After that, 18.
17. 17 is fine.
Release the matter on 7.
17, well, 17 actually, well, we should have a holiday month, September in Guwahati, madam. Vishwa Puja, no vehicle, nothing.
Vishwakarma.
Yeah.
18. Okay, 19.
Convenient to my.
19.
19.
Wait, please, my. Appeal against conviction, my. Life imprisonment. My lord, paper book has not been called for.
Paper book has to be made.
Yes, please.
Correct. Okay, right. Mr.
PR Sarma.
PR Sharma appears for the appellant. Registry to prepare the paper book. Then in the IA, right? With the additional PP, not here. Additional PP is granted 2 weeks time to file written objection.
My lord, LCR has also.
I know, that's why I said paper book. LCR has come. LCR is here. It is reflected in the pause list. Have you got it? Yes. No, you don't have it. That's why you're not. Sorry. Okay, I'll list the matter after 2 weeks.
Deeply.
It is after. Or make it 3 weeks. Make it 3 weeks.
May I please, sir? So, in this matter, your lordship, I was pending, your lordship, for
Okay, we'll hear. But where are they? Okay, the main case, you're right. You're right, the main case. As the TCR has arrived, registry to prepare the paper. Okay. Now in the IA.
lordship, for the IA, they have already filed a written objection in regards to the IA. But in the IA, the objection they have filed, they are completely silent in regards to the grounds that we have taken for the bill and this appeal.
Doesn't matter, we won't
Yes.
go by, we'll go by what is there in the record.
Yes. Now, lordship, he has been behind the bar since 2 years, 5 months till now. And he is convicted under section 21.
21C.
21C, but the merits are in favor of the petition appellant here. Because the prosecution witnesses that has been prosecuted, PW 1 and 2, they are not the independent witnesses. Your lordship. They were called by the police
But how
themselves.
many witnesses are there?
There were 7 witnesses in total. And only 2 witnesses that were independent, they will be shown as an independent
Where is
witness.
where is the PP?
No.
Must be in the corridor. No. What to do?
Your lordship, may kindly go through the LC. I will submit my part.
No, I submit, you submit your part, I listen to them when. And another thing, my brother will not be here tomorrow. So we have, either we do it today or we do it some other day.
Maybe taken after some time. That is.
This is the last item. I've got single bench after this. So there's one hearing. There's one hearing. No, where the amended appeal petition has been filed or not?
It should become as, because substantial concern of.
Correct. No, the amended appeal also is not there in the record.
That was filed, okay, it's been filed now. Maybe up to vacation.
Okay, enough. Okay, right. You find out whether the amended appeal petition is there. or
Yeah,
not.
file.
Yeah, filed.
Filed.
Okay, right. On the prayer, the party plays the matter after vacation.
Not.
After vacation?
Under the heading.
Before vacation?
Not, I have no.
Let us learn
What?
how to, we have to learn a little bit. When do you want?
What's the very date?
15th,
15.
under the admission parliament.
What's the date? Maybe 17, 15, I mean.
17. Have we fixed anything else? No, 17.
No.
Great. Just a minute, in the meantime, the Mr. A.K. Sahewala will ensure that the amended appeal petition is in the record.
No.
Okay. Now what to do? Where is G. Buyan also? She's not here. Let's call people here. Or we call the AG. Your case is 21C,
Yes.
200, nearly 300 grams, Huh?
500
500 grams.
Yes.
So half a kg.
Yes. Now, lordship, in this case, there are 7 witnesses. Now, according to them, two independent witnesses, but that witnesses has been called by the police themselves. That can be clearly evident from the record. So
Naturally, they are always called by some.
they are gathering of more than 20% in 20 people in there. They could haven't taken any other person. But they have said, now the independent witness has himself said that he doesn't know what is the quantity. He have not seen seizing the same articles. Now again, the third witness, the Nazir Ahmed, the person who has mechanic who has just torn open the vehicle. He also stated that he was not being checked. Police has not checked him before entering the vehicle. And the police,
Where is the requirement of checking a person before entering a vehicle?
because Lordship, this is the case of NDPS where it is the
No, that section 50 will apply only when something is recovered from a body of a person. Or you're talking about 42,
yes, sir.
huh? Enclosed space or
Yes,
what?
no, sir. It was
For a
taken,
vehicle.
it was taken in
I
a
know
closed space. in the
whether
vehicle.
that will apply to a vehicle. What vehicle was it?
It was a Bolero car. Nexon Tata car. Private vehicle.
Any citation which show that for entering a car, you need this 42?
That I do not have
That-
right now.
How?
But there are other
Yeah,
grounds I would like to.
Okay, then you go to those grounds in which you're going to have some backup citations. Otherwise, you cannot just make submissions without backing up your submissions. Yes.
My senior has to leave because her junior father-in-law has expired today. So she has to leave.
Who's your senior?
Be Bhuya, Miss Be Bhuya.
What about A Begum?
She has also gone to home. It informed me.
He informed me that she's gone for lunch.
Yes, they just reached home.
For lunch.
No,
Whose father-in-law expired?
Bhuya.
Bhuya junior's father-in-law.
Huh?
Bhuya's junior's father-in-law expired.
Okay, understandable. Bhuya, understandable. But A Begum, why did she go home?
She has forgot that there is another matter.
Oh, she forgot.
Yes.
Why don't you argue?
I have not. No, don't have any. Hmm.
Yes, so the APP forgot that there was a case. Genuine reason.
Let me fix a start date if possible.
Okay, right. A genuine prayer has been made on behalf of the additional PPs on the ground that the junior of Mrs. B. Bhuyan had expired, had expired. And the father-in-law of the Miss Bhuyan's junior had expired. And on account of Miss A. Begum having forgotten that there was another case pending before. List the matter. When?
Next.
Anytime, when you did. Monday, which we thought it.
Tenth.
Really?
Public.
Lord, today I need the accommodation because my lord senior advocate K.N. Chaudhary, he's in Itanagar bench today, my lord. He has asked me to take a adjournment for today, my lord.
This case is never ending. I think I'll release it from Partner. No. Why should I keep it with me? I think that's the best. Right. Mr.
B. Prakash.
B. Prakashta, learned counsel for the petitioner praised for adjournment and submits that his senior Mr. K. Chaudhary is out of state. Mr. N.J. Khataner appears for the secondary education department,
Elementary.
elementary education. On considering the fact that the matter has been adjourned time and again, this court is of the view that the matter should be released from party. Accordingly, the matter is released from party, list the matter before the appropriate bench in the next week. No, throw that away, throw that away.
The application against review petition against order dated 7/8/24, my lord. Certain facts were not put on record, my lord.
So there was a notice for sale, correct?
Yes.
There was a notice for sale on,
Installation also.
then after notice for sale, there was an auction.
Right.
Auction held.
Yes.
You were the only participant
Yes.
in the
that year,
auction,
Yes.
huh?
In
You
that
were the
year.
only one.
Yes, ma'am.
And then after your participation, auction was cancelled,
Yes.
huh?
It was cancelled, ma'am.
Let us see the order cancelling the auction.
Not only cancel, my lord, there, before the repetition was moved, my lord, and at the, in page number, fresh notice was also issued.
Where is that?
Lordship will find in page number 64. I can provide a smart note, my lord.
And that is
Yes,
page 37, ma'am, the cancellation of auction.
64.
64 is the fresh notice, thereafter, correct notice. please. 64.
64. Notice for
Please.
sale dated.
My lord. Yes, ma'am. 64, my lord. This is the, after that cancellation, the notice was saying the cancellation, the proper correct.
No, yeah, fresh sale notice is only after cancelling
Yes,
the
my
sale
lord.
notice.
Thereafter, it was when the Lordship will find a page 64, this was done, my lord. The fresh, correct advertisement, my lord. Thereafter, in page 65, the
Just a
person.
minute, what is that date?
Date, my lord, it is 22/1/22. my lord.
Where do you get that? Where do you get the date?
Lordship.
You all are so fast in saying the date without being able to identify.
Lordship will turn to page number 57. This is an advertisement and soliciting that. This is for general information.
57 is a part of the judgment.
No,
Order.
well, 14, it was given in 22/1/22, my lord. That is memo number so and so.
Counsel, I have got the petition in front of me. Pagination has been done by you.
Lordship.
57 is part of the order, judgment.
Sorry, 67. Annex 12. 67, my lord. It is given, this is for general information that the sale notice published in Assam Tribune and Proceeding dated 22/1/2022, that time page number 64, my lord. Memo number so and so, inviting publication land property so and so. This so and so name on 4/12.
Where is this cancellation notice? Where is this one?
That is page 37, ma'am.
37 is the
No,
later
67.
he challenged.
The cancellation of auction, that was challenge, ma'am.
That was challenge.
13/1/22 was challenged.
Yes,
13/1/22.
Yes, ma'am. My lord,
You see, this fresh sale notice is of no use. You have already sold it.
No, so
You have already sold it, and then the cancel the sale notice.
thereafter it was not thereafter he filed a writ petition, my lord. In
This
the
petition
meantime, on
filed when?
24/1/2022, ma'am.
24/1/22 case, it was filed,
What?
Yes, ma'am.
but it was moved on 23/2/22. 23/2, it was moved for the first time.
Just a minute.
And
By that time, everything has been
23 to 22.
23/2/22, it was moved.
This petition moved.
But
and
before
and
that,
my lord, and on that date, my lord, interim order was passed.
well, before that, certain events has taken place, my lord. On 22/1/22, fresh sale notice of the third, this is sale already been published in page number 64. In 24/1/22, it petition was filed. On 1/2/22, it.
Okay, it
lakh
did not
rupees-
mention this fresh sale notice.
Yes, my lord. This and 8 lakh rupees also we paid, my lord.
That is the
We have received it.
another interesting thing, my lord. What is the outcome of the subsequent sale notice? My lord? Was there
Yes.
any bidder? And if that's so, who is the bidder? And my lord, here what they have done, my lord.
Okay, now in this fresh sale notice that was issued, where is this fresh sale notice?
Lordship in page 64. ma'am. Then it's 11. Thereafter that, after the
Just
sale
a
notice.
minute, just a minute. Don't be in a hurry. Let us try to see what is the thing. In exercise of so.
This sale notice was never on selling.
There is no date for
My lord,
when the
this is-
auction
my
will.
lord, that there is no date, my lord.
On 4/2.
Yes, it is 22/1/2022. It was published, my lord. That I will
So
show
this
it.
is going to be held on 4/2.
Yes, my lord.
So
What
what
had
happened on 4/2?
My lord, what had happened, my lord? On 1/2, next page, my lord. Page 65. 1/2/2022, the person against the particular land is to be sold. He came before the office and deposited 8 lakh rupees. Next page 65.
When?
This is 1/2.
1/2.
1/2. And next page 66. On 28/2, he deposited another 5,11,126 rupees. Total will be 13 lakhs something, my lord.
So in your affidavit in opposition, did you mention all that?
No, these things are missing, my lord. Total he has paid
Everything
13.
was concealed, my lord. What I'm saying, my lord. And
Lordship,
you were-
next page, Lordship,
Yes,
the next page.
66, I am also.
67. Page 67,
No,
the
but-
type copy.
My lord, 66 for plans, my lord. Kindly see 66 for they have written, my lord. Here, they have collected 5,11,000, 12,126. Kindly see below line, my lord, on account of, well, here, my lord, liquidation of loan amount, account number 23, subject to outcome of the WBC number. They are not subject to the outcome of the WBC number, my lord.
Yes, in the meantime, it
My
is
lord,
informed
here,
that
my lord,
it
I
is
had
in
offered
file.
76 lakh. It is got money, my lord. And now they have settled 113 lakh, my lord. How they are, my lord, I don't know what is their consideration, my lord.
Huh?
I had offered 76 lakh against the property.
And now
And they are 13 lakhs, only 13 lakhs.
This is the that petitioner's land, my lord. Lordship will turn to
How
next
they-
page number
it is
67.
Public
you
accident,
are,
my lord.
you are suddenly feeling very sorry for the pet, for
But
that person.
that is the amount, my lord. In the auction, it's a different thing, my lord. In page number 67, it has been cancelled, my lord. There's a publication in the newspaper that tender has been cancelled. Thereafter, the writ petition has moved on 23/2/2022.
Correct. But you have not informed him regarding all this.
Yes, this is that I have to admit that.
My lord, here, my lord,
And you and neither have you made any of this ever. Have you? But let us see what is your averment.
I am not the petitioner, my lord.
my lord,
No, let us see your averment in your affidavit.
my lord.
Yes, that has not been brought on record, my lord. These subsequent
So,
developments.
These are so why shouldn't you suffer?
Nothing, my lord. Here, my lord, subsequently they have filed on affidavit in opposition on 1/9/2022 itself, my lord. They could have wrote everything.
Sir,
All
yes.
are afterthoughts, my lord.
Now, these things.
And now, my lord, how 76 lakh property can be given to 13 lakhs, my lord? It is not a AFC's personal property, my lord.
76 lakhs minus 13.
13, my lord.
That means 63.
63 lakhs, my lord. How, my lord?
Maybe they were given, maybe they were given 5 rupees to or 10 rupees to have chai.
This is
And that's
Well,
why they gave
This is
discount.
all are after
60 lakhs.
my lord. These are all after. Nothing else causing decision is given to review the
person-
petition, my lord.
the person who is
Yes,
land
madam.
has been auctioned, he came before the office and deposited the amount the amount which is due.
And let us see what you have written in your affidavit in opposition.
In the present, yes, madam.
Yeah, in the writ petition.
Page number 38 onwards. that initial that order, that advertisement, there is the incorrect tag number, so let us paste. Page number, paragraph number 7, page number 14. Name was error and there was a tag number was, there was error. So there was trace publication was there. Then the person whose land was to be sold, he came before the FC, Assam Financial Corporation, to liquidate his amount, the due amount. When the correct advertisement was published.
Nothing was mentioned, huh?
Nothing.
Regarding payment of 8 lakhs and that.
No, that was not there, my lord. I admit, my lord, that was not
Moreover,
put on record, my lord.
payment receipt also, my lord, they admitted that subject to the outcome of the read petition.
In the meantime, it
Because
was
they
not
knew
filed.
the consequence of the read petition, because they knew. That is why, my lord, in the last receipt, my lord, in the money receipt, they are written. That is the subject to the outcome of the read petition. So, my lord, there is nothing to, my lord, I think, to review this order, my lord. And for giving full opportunities, my lord. And moreover, my lord,
How was this rupees 8 lakh given by the landowner by check?
yes, that is to be inquired, my lord.
Was it by check or by cash?
My lord, it indicates this page number 65 indicated cash because the tick mark is in the cash.
Number
65.
Oh, very interesting.
Yes, my lord.
Hmm.
All are afterthoughts, my lord.
It cannot be, my lord, it is prior to that
So,
event.
so this 65, oh, that's in cash.
Yes, man. This is the
And this 5 lakhs also is in cash.
cash, man. This was his own, when the advertisement was correct advertisement was published, he came
From
to
where
know
did he have the money, 8 lakhs in cash?
that. Only thing is that we have,
And under his mattress?
man, that I cannot, man. Only thing is that this, when the correct advertisement, he got to know that this his land is under for sale. Then he came before the FCI and Financial Corporation, and he handed over this.
Very good for you. Okay.
And
right.
even after filing the FCI affidavit, they did not inform the owner that the case is going on. So it just deposit the money.
What?
My lord, they are saying that they deposit the cash, my lord. They did not know the about the read petition.
Where everything?
No, my lord, they are just arguing.
No,
my
no,
lord.
that when the correct advertisement was published, then the owner of the land came before the Assam Financial Corporation,
Correct
deposited the.
advertisement. Which report? Let us see one.
Page 64 is the correct, when the advertisement was published, madam. With on his name was made, name address was given, then he approached the Assam Financial Corporation.
So this fresh sale, this correct notice for sale.
Yes.
Does not supersede the earlier notification. There's nothing here which says that it supersedes the earlier sale notice.
Nothing there.
Yeah, right. Heard Mr. S. Bora, Senate Counsel for the review petition. Also heard Mr. S. Thakur, Senate Counsel for the respondent number.
On
Sold.
sold this matter.
The review petition who was the respondent numbers?
It is not one matter.
No, respond in the writ petition.
Review petition was the one, respondent number one in the repeat.
Who was the respondent number one?
Yes.
In the review petition, in the writ petition. It has, say in WPC 1169 of 2020.
Yes.
Put to challenge. The impugned order dated 7/8/2020. Passed with WPC 1169 of 2020. On the ground that the the ground that certain vital and relevant facts had not been brought on record by the review petition due to which the erroneous impugned order dated 7/8/2024 was passed with WPC 1169 2020. The facts of the case is that pursuant to a notice for sale dated 9/11/2021 issued by the Assam Financial Corporation for the minimum offset price, OFF-SET, offset price, of rupees 75 lakh, the petitioners offered price of 75,51,00 was accepted by the respondent authority in the public auction held on 25/11/2024.
No, my lord, it is 21.
25/11/2021. 2021. Wherein the writ petitioner was the only participant. The writ petitioner accordingly deposited earnest money of rupees 7,55,100 by banker's check dated 22/11/2022. However, in pursuance to negotiation held between the petitioner and the respondent and the Assam Financial Corporation, the writ petitioner agreed to enhance his bid amount by another 9,000, thereby rounding off the bid of the petitioner from 75,51,000 to rupees 75,60,000 on 24/12/2021. 21. The review petitioner, that is Assam Financial Corporation, thereafter cancelled the public auction by communication dated 13/01/2022, informing the petitioner about the same and returned the earnest money of rupees 7,55,100, by check number 803,096 dated 12/1/2023.
Yes, my lord, but that was not never deposited, my lord. Yet it had never deposited. my lord.
13/1/2023. However, the said amount was not encashed by the petitioner.
13/1/22. Not 23, no,
13/1.
22.
13/1/22.
Not 20. Page number 19 also clear.
Next para. I think it's para 4, huh? Para. Of the related. Next para. Being agreed with the action of the respondent number, being agreed with the action of the Assam Financial Corporation. The petitioner filed the present petition, filed WPC 1169 of 2020 on 24/1/2022. And the same was listed before this court on 23/2/2020.
Yes, any demo.com.
Wherein an interim order was passed to the effect that the AFC should not alienate the auction land. Next paragraph. This court, no, next paragraph. The prayer of the writ petition, in WPC 1169 of 2022 was for a direction to be issued to the respondent authorities, to accept the remaining bid amount of rupees 68,04,900 for the auction land. Next part. The Assam Financial Corporation thereafter submitted their affidavit with and the only stand taken by them
By that,
Huh?
In the meantime, contempt case was filed, my lord. That's pending.
That's a different thing. That's a different issue.
Page 40, man. That's it.
And the only stand taken by them was that the sale notice dated 9/11/21 was cancelled. No, and 9/11/21 and the public auction held on 25/11/21 was cancelled on technical ground. And that the 10% and earnest money had been returned to the writ petition. Further, it had been observed that the sale notice dated 9/11/2021 at serial number 1 contained two mistakes, which are as follows. Para 7 Roman 1 and 7 Roman 2 at page 21 and 22 of the writ petition. Thus, due to the unintentional, no, next para. Thus, the stand of the AFC was that due to the unintentional clerical mistake in the sale notice dated 9/11/2021, the sale notice had been cancelled. That's all. Next one. On considering the stand taken by the respondent authority, considering the stand taken by the writ petition and the AFC. This court held that though the public auction had been cancelled on technical ground, there was no elaboration as to what was meant by inverted commas technical ground by the AFC. This court just held that. The explanation given by the vague explanation given by the AFC for cancelling the public auction by using the term inverted commas technical ground could not be accepted. This court held that when the land document had clearly defined the area of the land, which had not been controverted by any person, there was no justification for the AFC to cancel the auction, only because a certain number, only because the AFC had forgotten to add a certain number in the auction book. The relevant portions of the impugned order dated 7/8/24 passed in WPC 1169 of 2020 is reproduced here below as follows. Para 13, 14, and 15. Correct?
Yes.
Good. Chapter 40, 50, 16. Huh? Next up. The AFC has now come up with the present review petition. Stating that the impugned order dated 7/8/24 passed in WPC 1169 of 20 should be reviewed as certain vital facts had not been brought to the notice of the court by the AFC, by the review petition. He submit that the AFC had forgotten to inform this court that a fresh sale notice dated 22/1/22 had been published by the AFC which was never put to challenge by the writ petition. Further, the review petition had also forgotten to mention the fact that the borrower of the loan, namely Sri Bhupendra Ray Barwa, had deposited rupees 8 lakh by cash on 1/2/22, followed by another amount of rupees 5,11,126 by cash on 28/2/22, thereby liquidating the entire dues, liquidating his entire dues, amounting to rupees 13,11,120. He submits that if the above facts had been brought to the notice,
Page number 67, there was the advertisement of cancellation, my lord. The the 67 is the type copy, 68 is the cancellation published in the newspaper.
he submits that in view of the borrower of the loan amount having liquidated the loan amount on 28/2/22. Yes. Then
my lord, page number 67 is the type copy that it was published on 3/2/22 that earlier
the sale notice,
has been cancelled.
the
Public auction is in there.
sale notice published on 22/1/22 was cancelled on
3/2/22.
where do you get the 3/2?
My lord,
On
the paper published
3/2/22.
this is published in paper, my lord, Assam Tribune and Petition.
3/2/22.
Lordship, page 68, my lord.
Okay, anyway, on 3/2/22 it was cancelled
This was cancelled.
because the loan was liquidated. Okay, the learned counsel for the review petitioner that says that impugn order should be set aside. Should be recalled. Recalled. And the review, the writ petition should be dismissed. Correct?
Yes.
Or you wanted that it should be allowed?
Lord will review it that time.
No. So what do you want in review? In the review, do you want a you want the writ petition to be allowed or dismissed? Then that's what I'm saying. Next, Mr. S. Hawk, the learned counsel for the writ petition. That is the respondent number 1 in the present review petition. Submit that the review petition, the contents of the review petition is all an afterthought. And all the submissions made on fact in the review petition were never a part of the affidavit in a position filed by the AFC,
192.
that is response number 1 to 4 in WPC 1169 of 2020.
That was filed 19
He
2020.
submit that the affidavit filed by the respondents number 1 to 4, that the affidavit filed by the respondent 1 to 4 in WPC 1169 of 2020. Whatever I said. They submit that the affidavit filed by in the inside sir, had been filed on 1/9/2020. That is long after the alleged issuance of the fresh sale notice dated 4/2/22 and the alleged repayment of the loan amount in the month of February 22 and the cancellation of the fresh sale notice dated 22/1/22 on 3/2/22. How can it be? You don't even know what they are saying. Pushpa. What do I think? No, 22/1/20. 22/1/20. No, not 22/1/22. On 3/2/20. The same not being, the said fact not being a part of the affidavit of the review petitioner filed on 1/9/22 in WPC 1169 of 20. The same is the same the what fabricated, no, the huh? The the statements made in the present review petition.
Not tenable.
Huh?
Not tenable.
Should not be accepted. I have heard the learned counsel for the part.
Another aspect that offering of bid, petitioner had offered 75 lakhs.
Okay, right. There's one more thing, right? The counsel for the writ petition further submit that when the auction of the property had been settled with the petition, with the writ petition for rupees 75,51,00, which was subsequently enhanced to rupees how much?
75,60,000.
75,60,000 on 24/12/2022.
21.
Huh? 24/12/2022. Comma. It is not understood as to how the review petitioners could have accepted rupees
13 lakh.
13,
13 lakh 11,000.
comma 11, comma
120.
120 as final settlement of the dues with the alleged borrower, comma thereby losing out on approximately how much? On approximately calculation has to be done. The thereby losing out on approximately
62,040.
62,48,88. Huh? They don't want money, they just want one rasgulla and one cup of chai.
Yes.
Rasgulla may be covered in diamond circle. Full stop. What do you say? Okay, next, right. I have heard the learned concept for the as can be seen from the fact of, from the submissions made by the council for the past and the documents on record. The petition, the writ petition that participated in public office on the basis of the state notice dated 9/11/21, and his bid had been accepted at the rate of 75,51,0. The same was enhanced 75,60,0 on 24/7/22, as agreed by the Assam Financial Corporation. The only stand taken by the AFC in cancelling the public auction held on 25/11/21, while communication dated 13/1/23 was on the ground that was on account of technical ground. Good, technical ground. It had all wherein it had been stated that fresh sale notice would be public. Oh, don't say that. Don't say that. Wherein cut from wherein you. In the affidavit in a position filed by the AFC on 1/9/22 in WPC 1169 of 2020. The ground that the ground for cancelling the sale notice was that there were two mistakes.
My lord has appropriately earlier.
Huh?
Earlier dictated.
There were two mistakes mentioned in serial number 1 of the said note. No other reason had been given by the AFC for cancelling the sale notice and the subsequent and the consequential public offer. Keeping the above in view, WPC also had been decided by the impugner. Next up. The review petitioner has now sought to has now sought to review the impugner on the ground that a fresh state notice had been issued on 22/1/20 and that the loan amount had been repaid in full by the borrower, Upendra Ray Barwa, on 1/2/22 and 28/2/22, by depositing rupees 13,11,120 by cash. No such averment has been made in the affidavit filed in WPC number 1169/20 by the AF. Further. The cancellation of the fresh sale notice, alleged fresh sale notice dated 22/1/20 on 3/2/22. Further, there is no mention of the fresh sale notice dated 22/1/20 in the affidavit filed by the AFC in WPC number 3. The cancellation of the fresh sale notice dated 22/1/20 on 3/2/20 by the AFC is also not mentioned in the affidavit filed by the AFC in WPC number 3. On considering the provisions of Order 47 CPC and the fact that a completely new story has been made out by way of the present review petition. This court is of the view that no grounds for review have been made up by the review petition. The review petition is accordingly dismissed. Right.
Okay.
I'm getting.
May I please your last
Yes, who's for the other side?
other side, government, my lord, standing council, secondary education. The
Secretary Education, yes, sir. Any objection? No, correct. Heard Ms. A. Bazar Barwa,
Gujarat.
learned counsel for the applicant to submit that the school name was wrongly written in
First title. In WPC number,
wait. In WPC, in the cost title
yes, ma'am.
of WPC 2055 of 2025. She submit that in the cost title or where?
In the cost title,
In
my
the
lord.
cost title.
In the cost title.
He submits that respondent number 4
Yes.
should have been recorded as the
Kothal
headmaster
of Kothal.
of Subansiri Kai Warta, KAIWARTA.
That is a wrong, my lord. That
That's
is
the
a-
wrong one.
the-
No, that is the. Huh?
No, in earlier, yes,
Was wrong, what did I say? Should have been recorded as the headmaster, this one, of Kathal Para High School PO, it is here,
yes,
instead of the high school, Subansiri Kaiwata High School, in the writ petition. Huh?
petition. And in order, order first in the writ petition, the body of the order in paragraph 4, that is also reflected.
Accordingly,
Mm.
accordingly, while disposing of the writ petition by
Paragraph 4, my lord.
wait,
Actually, it should be paragraph.
just a minute, wide order dated 10/4/2025.
Mm.
The the cause title to the respondent number 4 and no, what the cause title to respondent number 4 is wrongly recorded. Full stop. Similarly, the further. Para 4, actually, there should be para 2 actually. No?
Actually,
In fact, further, para 4 of the impugned order dated 10/4/2024 had incorrectly incorrectly recorded the respondent number 4 as the headmaster of Subansiri Kai Warta High School, Baby Jia Lakipur, instead of
Kathar
that is point number. He accordingly submits that the mistake should be corrected by allowing the writ petitioner to file an amended writ petition.
Since the petition is dispose of mine.
Okay, yeah.
The registry.
Should be allowed to file a has to file. Otherwise, how will it be recorded in the CIS?
Registry will correct the.
Yeah.
Registry will correct.
So what I say? You corrected in the cause title of the dispose of writ petition at relating to respondent number 4 and in the impugned order at para 4. Mr. Learned Counsel for the Secondary Education Department submits that he has got no objection to the prayer made by the applicant's counsel. Next, in view of the submissions made by the counsel for the parties and keeping in view the fact that there has been a mistake committed by the learned by the applicant in the cause title relating to para 4, which had led to the unintentional mistake in para 4 of the impugned order dated 10/4/25 passed in 2055 of 2025. The application for correction is accordingly allowed. Correction of the cause title of the writ petition and the impugned order is accordingly allowed. Registry directed to correct the cause title of the respondent number 4 in the
Order passed.
in the disposal of writ petition and in the cause title of respondent number 4, cause title relating to respondent number 4 and para 4 of the impugned order dated 10/4/2025 passed in WPC 2055 of 2020. The respondent number 4 shall accordingly be considered to be the headmaster of
Katalpur High School.
Kathar Pala System instead of headmaster of Census System. The I is accordingly disposed of. Then in the review petition.
Review. Same pair.
So you pick the review and I in one order. That is better. Enough?
I in review order.
No, I is separate.
I is separate.
I will be with the disposal of WPC.
WPC there, dispose of distributed.
What are they say out there?
Review may be closed.
Review may be closed, my.
They just say in the review, in view of the order dated so and so pass in IAC 2466 of 2025. The review or the review petition is accordingly closed.
Closed.
It's closed accordingly.